Have you ever looked at a modern bureaucratic requirement, a building code, a tax filing, or even a seatbelt law, and felt a nagging sense that the government's authority operates on a frequency you don't quite understand? For many, there's a growing suspicion that our legal reality has shifted away from a constitutional republic toward a massive, complex corporate structure. The truth lies within the hidden architecture of our legal system. The Uniform Commercial Code, UCC. To the uninitiated, the UCC is merely a set of rules for business. To the investigative historian, it is the operating system for a corporate facsimile of the United States, a system where citizens are treated as assets and the law of the land has been replaced by the law of the merchant. In 1871, while America was broken by civil war and drowning in debt, a foreign alliance of European bankers struck a deal with Congress. Financial rescue in exchange for full administrative control. The United States Corporation was born privately owned, headquartered in D.C. and operating outside the Constitution. Since then, every president except a few served as CEO of this corporation. The Constitution was quietly replaced with a corporate facsimile, a duplicate. Senators once appointed by state legislatures became political salesmen. In 1933, the United States were declared in bankruptcy, and on June 5th, the same year, the U.S. Congress passed a public resolution called HJR 192 with an executive order that invalidated gold clauses in contracts and commerce. President Franklin D. Roosevelt, acting as corporate trustee, signed over the assets of the people, including their labor, their property, and future earnings. Every citizen became a corporate asset collateral to foreign shareholders. The birth certificate became a bond, monetized in the form of trusts, a guarantee of repayment of debts contracted by the government, and the Social Security number became a tracking code. The United States became a franchise of global financiers in London, the Vatican, and the British Crown. The latter infiltrated schools, media, and the government. They rewrote history, told you that America was a democracy, not a constitutional republic. They installed laws in all caps. They transformed major states into corporate entities and used wars, crises, inflation, and fear to expand their control. The IRS was born. Income tax was imposed, and the Federal Reserve Act of 1913 placed America's currency under the control of private central banks. In the absence of a reference of concrete monetary value, precious materials, gold as silver, platinum, the fiat system, a colored currency, was put in place, the trust of which would only depend on the consent that the citizens give it. Hence, in 1938, all the judges of higher courts, the top attorneys, and the U.S. attorneys were called into a secret meeting, and they all were told that, I quote, America was a bankrupt nation, and that it was owned completely by its creditors, the central bank, British banks, via, and sometimes from British private families and corporates. With the aforementioned secret meeting adjourned, it was decided that the courts would no longer operate under common law at the federal level. This shift was codified in the Supreme Court's decision in Erie Railroad versus Tompkins, 1938. Contrast this with the earlier case of Swift versus Tyson, 1842, where the court recognized federal common law. In the 1938 Tompkins trial, the victim of a railroad accident was denied damages because there was an absence of a commercial contract between the victim and the corporation. The victim lacked standing because he was not part of the commercial machinery. All federal cases would be judged under the negotiable instruments law. The courts will act under the law of merchants. This law of merchants is effectively admiralty or maritime law, the law of the sea, applied to dry land. Because the system redefined everyone as an instrument of commerce, the courts began operating under what they now call statutory jurisdiction, a neutral term for a merchant-controlled legal environment. In admiralty, no court has jurisdiction unless there is a valid international contract in dispute. When you know it is admiralty jurisdiction and that the judges, also a court clerk, a bailiff, a lawyer involved, have admitted on the record that you're in admiralty court, you can ask that the international maritime contract to which you are supposedly party, and which you supposedly have breached, be placed into evidence. Ask to see the contract.
Objection. There is no discretion to ignore the lack of jurisdiction. Juris versus United States. Jurisdiction is fundamental, and a judgment rendered by a court that does not have jurisdiction in here is void ab initio, and that is application of Y300 P.132 versus Caveat. Once jurisdiction is challenged, the court cannot proceed when it clearly appears the court lacks jurisdiction. The court has no authority to reach merits, but rather should dismiss the action. Malo versus United States 505 F2D. When jurisdiction is challenged, the party invoking jurisdiction has the burden of establishing. Basso versus U.S. Power Light Company. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not attain jurisdiction by service of process, nor even arrest and compelled appearance. I'm here by way of threat, duress, coercion. I'm going to make that clear for the record every time I have to appear here, if I have to appear here. The only reason I'm appearing here is by way of your threat, duress, coercion, or your company's threat, duress, coercion.
No court has admiralty/maritime jurisdiction unless there is a valid international maritime contract that has been breached. If the court is taking jurisdiction in admiralty, then place the contract into evidence so that you may challenge the validity of the contract. What they would have to do is place the national debts into evidence. They would have to admit that the international bankers own the whole nation and that we are the bankers' slaves. The common law, natural or constitutional law, is based on our Creator's laws as originally presented by Moses. Anytime someone is charged under the common law, they must be a damaged party. You are free under the common law to do anything you please, as long as you do not infringe on the life, liberty, or property of someone else. For example, when you cross state lines, you will probably see a sign which says buckle your seatbelt. It's the law. This cannot be common law, because who would you injure if you did not buckle up? Nobody. This is compelled performance. But common law cannot compel performance. Any violation of common law is a criminal act that is punishable. Equity law is law which compels performance. It compels you to perform to the exact letter of any contract that you are under. So if you have compelled performance, there must be a contract somewhere and you are being compelled to perform under the obligation of the contract. Now, this can only be a civil action, not criminal. In equity jurisdiction, you cannot be tried criminally, but you could be compelled to perform to the letter of the contracts. If you then refuse to perform as directed by the court, you could be charged with contempt of court. This is a criminal action. Are our seatbelt laws equity laws? No.
I'll just read the charge out quickly for you. So it's at Melbourne on the 13th of September 2020. Did fail to comply with the direction given to that person. That direction being to stay at home unless for essential shopping, work, exercise or caregiving purposes, having been given by a person exercising the power granted by the Chief Health Officer under Section 199 of the Public Health and Wellbeing Act. So in relation to that charge today, are you intending to plead guilty or not guilty?
So, Your Honour, I am the living woman.
Yes.
I'm the beneficiary of the Melbourne Trust. I do not consent to contract or joinder, and I waive the benefits on offer.
Okay, so I'll take that that statement to mean that you're intending to plead not guilty today. So thank you for that. I think, Mr. Prosecutor, in this circumstance, contest mentioned?
Yes, Your Honour.
Yes.
Your Honour, I've been given a copy of the letter provided by Ms. Ben to the court.
Oh, yes.
I hadn't had any prior correspondence. I can't see that there's been any case commenting in the matter, but certainly no objection to the matter going straight to contest mention.
Yes, thank you. I think it's suitable. I'll get a date, case contest mention date. So, Ms. So the next, I'll give you a next date now. This will be the contest mention date, okay? So there's various steps that the matter has to go through before it gets to a contested hearing. So I understand that's what you'd be looking for eventually anyway, would be a contested hearing or some chance to address the court in relation to the charge. Today is only a mention court, so we're sort of triaging matters into basically matters that are going to be pleas of guilty or pleas of not guilty. So not guilty pleas need to go down a different pathway. So if you just hold on there for a second, we'll get a new court date.
So, Your Honour, are you administering my trust without my consent?
No, No, there's no administration of any trust at the moment, so we're just dealing with the matter under the Criminal Procedure Act. Okay, so that's 2009, an act in force in Victoria, and the next step will be a mention date under the Criminal Procedure Act under Section 55 of that Act. So if you take it under Section 55 of the Criminal Procedure Act, that'll be the next court date in relation to that, and that'll set out the process of what's occurring.
I do not consent to contract or joinder, and I waive the benefits on offer.
Thank you, Miss. Your matter now is booked in for the next court steps to occur. The next court date is the 7th of December. Okay, so that'll be a contest mention back online in the Melbourne Magistrates Court. Okay, so that might take between 15 minutes and half an hour, depending on what's discussed on that day. But that mention date will give you a better chance to discuss your matter further. Okay, and the submissions you wish to make. Okay, so thank you for your time today in court, and you're now excused.
Thank you for your time, Your Honour.
7th of September.
Thank you. We'll just confirm. You're on the line there. You can see and hear us.
Yes, can you hear me?
Yes, I can. Thank you.
Your Honour, is an application to withdraw this matter.
All right. Thank you. On the prosecution application to have the charge withdrawn, the charge is now struck out. Thank you. The charge has now been struck out. You may be excused.
Thank you. Thank you, Your Honour.
Thank you.
To navigate this system, one must master the concept of the colorable. In legal terms, something is colorable when it has the appearance of being genuine but lacks substance. It is a counterfeit or feigned version of the truth. Maybe it looks like $1, and maybe it spends like $1, but if it's not redeemable for lawful money like silver or gold, it is colorable, such as the fiat system. It is fake and false. The use of colorable money creates a legal trap, because a common law court cannot adjudicate contracts involving substance-less Federal Reserve notes. The government had to establish a colorable jurisdiction to match its colorable currency. If a Federal Reserve note is used in a contract, then the contract becomes a colorable contract. This system is codified as the Uniform Commercial Code, UCC. When you use this money, you are accepting a compelled benefit, the privilege of discharging debt with limited liability, which implicitly obligates you to follow every associated statute and regulation.
For the record, my name is Ryan Thor. I'm the living man. I am not the entity known as Ryan Michael Thor, just to clear that. I am here on special appearance under threat, duress, and coercion to challenge subject matter jurisdiction and also personal jurisdiction as well. I filed my paperwork for you on Friday, and the clerk illegally denied it. I went again this morning and filed my paperwork again for you. The clerk again illegally denied it, even though I gave her a notice telling her it's a felony for her not to accept my paperwork. And actually, it's in law, it's considered filed when I gave it to her.
Okay.
So there.
What do you want to do today, sir?
Well, Your Honor, I mean, I'm going to have to ask a few questions first, which first of all is I need to understand the nature and the cause of the charges against me, as well as I need to know, is this a civil jurisdiction or criminal jurisdiction?
Okay, it's criminal jurisdiction.
Criminal.
It's traffic infraction court, so no possibility of going to jail on any of this. You've settled one of your counts. You just proof of correction on August 26, 2022, or Ryan Michael Thor did. Are you saying that's not you?
Ryan Thor is the living man. Ryan Michael Thor is the defendant in error. It's the artificial person. So thank you, Your Honor. Let the record of the court show that the action against me is criminal. And now I have another question, because the Constitution grants us two different criminal jurisdictions, okay? One criminal jurisdiction is under the common law, and the other is under the criminal jurisdiction of admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. Well, I need to know which of these two jurisdictions that you intend to try me. It's very important because they're done different ways. The rules of civil procedure are very different in a criminal jurisdiction, obviously for common law, and a military.
Civilly, no one's asking you, no. So we just need to show, were you able to cure your license with the DMV, or you don't know?
Your Honor, I need to get these other questions answered. I need to know what the jurisdiction is, and I need to know also who the injured party is. You know, the nature and cause of this. I need to know who the injured party is.
Okay,
I need to know who's bringing the claim.
How about, okay, the state is. So here's the deal. Do you want to have a trial date? I can give you many trial different dates, and you come in and you can ask all the questions, and they have to prove the charges against you. So
Thank you, Your Honor, but I don't think you'd be violating your oath of office by doing your duty under the Constitution. Okay?
Mr. Thor, I'm going to have to come back to your case because I have all these other cases, and I'll take all the time in the world to do because you add on today. Wait, what's on the calendar?
You know, Your Honor, I just motioned for a dismissal because if this is a criminal jurisdiction, as you're claiming, I need to see a verified complaint and I need from the injured party, and I have to have an opportunity to face my accuser, as you mentioned at the beginning of this entire hearing. So who is the injured party? That's the question. Who's the injured party? Why am I here? I don't understand why I'm here.
You paid $440.32. All right, so what else? So he just has to count 1 and count 2, and he showed the proof of claim. All right, sir, I'm going to just exercise my discretion. I'm going to dismiss count 1 and dismiss count 2 and just order the fees that you've already paid to cover court costs. Okay?
So
No charges are pending against you. They've been dismissed in interest of justice.
So I'm letting the record show that the defendant, Ryan Michael Thor, with case CMZ 606-406, all charges are dismissed. Is that correct?
And whatever fees were paid are going towards court costs, okay?
Those fees are bail, and they should be returned after dismissal.
Okay. You know what? I don't have a problem with returning your fees. I don't.
Thank you.
All right. Wait. All right. Have a good day, Mr. Thor.
Thank you, ma'am. I appreciate your time.
You're very welcome. Next case, Matthew Martinez, CMZ 30058. Mr. Martinez, good morning, sir. Thank you for being patient. I know you're at the end of the calendar. Failure. Oh, Mr. Did you have an address change? Because the money comes back to whatever address you put in whoever the person was. So.
The address is proper.
Perfect.
Thank you so much. Have a great day.
Matthew Martinez, CMZ 30058. Martinez.
If the UCC is the cage, it also contains the key. In any legal system, the remedy is the mechanism that allows an individual to exit the law's requirements. Every law system must have 2 characteristics: remedy and recourse. Remedy is a way to get out from under the law, and recourse is if you have been damaged under the law, you can recover your loss. Within the UCC, this is found in Section 1-308, formerly 1-207, titled Performance or Acceptance Subject to Rights. By using a specific reservation of rights, you can perform a required action, such as signing a contract or paying a bill, without waiving your underlying common law rights. The phrase, without prejudice, all rights reserved, or UCC 1-308 serves as a formal rebuttal to the presumption that you have entered into a commercial agreement. It signals that you are not accepting the liability of a compelled benefit or an unrevealed contract born of your total ignorance. You express your intention to the party who receives the document that you're legally reserving your rights or recourse against them. You can sign just about any document with a UCC 1-308 reservation of rights, such as contracts, acknowledgments, controls, loans, and receipts.
Officer, to each charge could be up to a $500 fine, up to 6 months in jail.
I do not understand any charges. I only understand universal law and the right to live.
Well, you
to
pled
live in
not
peace
guilty.
and to live as I need to.
You pled not guilty in this
I never plead. Animals plead. Sound like bah, oink oink.
I have a paper with your signature on it, sir.
It says prime evidence standing right through it. You bring forward all natural forms of evidence that I'm not prime evidence. I am the living soil. The dirt, the water, and the air has its own voice, does it not? It all supports
Sir?
forms of life, does it not? I am a part of that life. I am not your corporate fiction.
Sir,
Do not taint me.
you're here today on an omnibus hearing. You've already pled not
I am
guilty.
here by special visitation to see to it that you do not taint my natural living man's name.
Are you prepared
That's
to
why
tell
I'm
the
here.
court if you wish to go to trial on this matter?
This is a trial. Tell
No,
me it's
this
not.
isn't a trial.
Here's my
This is
jury
an
of my
omnibus
peers.
hearing, sir.
You cannot produce a jury of my peers because all juries are selected from a pool of registered voters, and the instant a person registers to vote, their natural ability as a peer to comprehend natural law has been dissolved and turned into fiction. There cannot be raised a jury of my peers. It cannot be done.
Excuse me for just a moment.
No way. Get back here and finish this. Hey, get back here and finish this. The judge has left the courtroom. There you go.
Yeah,
There is nobody in this courtroom.
Yeah.
The judge has
Yeah.
walked out.
the judge will walk down there, walk down there.
I
Everybody up
said
and
no
out.
excuse.
Everybody up and out.
I'm not letting you
Up and out.
go.
That's it. Up and out, up and out. Follow the man.
While a remedy provides an exit, recourse is the ability to recover your loss if you have been damaged under the law. The UCC provides this bridge back to the Bill of Rights via Section 1-103.6. This section is vital because it explicitly states that the code must be construed in harmony with the common law. The code is complementary to the common law, which remains in force except where displaced by the code. The code cannot be read to preclude a common law action. The UCC must recognize common law to maintain its legitimacy. If it did not, the system would have to openly admit it is a purely predatory entity of national bankruptcy. By invoking UCC 1-103.6, you move back into a jurisdiction where a damaged party is required. Under common law, if there is no injured party and no verified complaint by a competent witness, the court lacks subject matter jurisdiction. You can compel a prosecutor to bring forth a real human being you have harmed, rather than a nameless statute you have violated.
I don't have to give it to you.
You're going to give it to me.
Am I?
Yeah, you are.
Okay, what crime are you suspect me of breaking?
You're walking around our vehicles looking into them.
Okay, is
Most
this-
normal people don't look into our patrol
Is this
cars.
public property?
Yes, it is.
Okay,
I told you you could walk back.
I have every right to
I
be
told
here.
you to stay away from our vehicles.
And I have every right to be around your
You just
vehicle.
walked over there looking inside the car, did you not?
I did, because
Yeah.
I have a right
Give me
to.
your ID.
I do not have to.
Yes, you do.
I do not.
You just went to our vehicles and looking at them.
Your vehicle.
No person is going to look into a patrol car.
Okay, well this.
No one's sitting there.
Those are police vehicles.
Not videos of vehicles.
Vehicles.
Yes.
They are
Okay.
police vehicles owned by the city.
Yes.
This is public property.
Yes.
I have every right to be on public property
Yes, you
and
do.
look in city-owned
Let me
vehicles.
tell you something, buddy, because I'm not lying with you.
Okay.
6 cops have been killed this week, in this month.
Okay.
And some guy walking around the parking lot recording vehicles is not, it's not normal.
Okay. Well, it's not normal, but is it illegal?
So what I'm
illegal?
going to do is I'm going to do a police report and figure out who you are.
Okay, is it illegal?
I didn't say it's illegal.
Okay, so.
But it's not normal.
Okay, am I being detained?
Yes, right now. you
Okay,
are.
so for what
I
crime?
need your information.
Oh, yeah, I'm not giving it to you.
Okay.
You can call a supervisor out here.
30.
If you don't know your rights, you don't have any rights. This man obviously knew his rights and sends the officer packing.
In a world where everything is contract, your greatest tool is the intentional reservation of rights. Modern statutory law operates on the presumption that you are a corporate asset exercising government benefits, and thus bound by every ordinance of the United States Corporation. The transition from a republic to a corporate franchise was designed to be subtle, hiding behind the colorable fictions of fiat currency and statutory codes. However, the law provides a door for those who know where the handle is. By utilizing the remedy of UCC 1-308 and the recourse of UCC 1-103.6, you reclaim the power of the sovereign. A common misconception suggests that false imprisonment requires a jail cell, handcuffs, or physical violence. However, the common law has always held a high regard for the freedom of locomotion, the primary right of a citizen to move freely without unauthorized interference. Imprisonment is not defined by stone walls, but by the unlawful restraint of an individual's will. As noted by the Supreme Court of Idaho in Griffin v. Clark, imprisonment is any restraint of the personal liberty of another. and prevention of his movements from place to place. Furthermore, the Supreme Court of Kansas in Garnier versus Squires clarified that the wrong may be committed by words alone, provided they operate on the will of the individual to the point where they fear to disregard the officer's command. If a person is compelled to stay where they do not wish to remain, or go where they do not wish to go, the law recognizes this as a total restraint of liberty. The breach of the peace filter for warrantless arrests.
Now, do you have a search warrant to be on my property?
Okay, I do not, okay?
Okay, so...
But, listen to me, alright? You can just provide this information for me, your IDs, if you live here.
I'm not providing you nothing, man. Matter of fact, get off my property right now if you don't have a search warrant.
Sir, I'm
asking you nice.
And I was asking you nicely as well.
Hey, sir, all I'm saying, if you don't have a search warrant, paperwork to be on my property, what crime do you suspect me of committing?
That I have right now is y'all failure to identify.
Just watch.
Okay, 38.02, failure to identify. One must already be under arrest for a crime that he has committed. What crime have I committed?
Failure to identify.
No.
In another example of many in pathetic policing, these two officers show how they try to manipulate citizens to give up their rights.
That's not a crime. That only becomes a crime once one has already lawfully... Be quiet. Let me educate this one. You hear me? Let me educate him. 38.02, failure to identify, only becomes a crime when one has already been lawfully arrested for a crime. Let me give you an example, sir, since I don't know who you is.
Detained.
Huh?
What about detained?
What am I being detained for?
Detained because you're suspicious activity.
No!
Where they clearly game planned how this would go, but unfortunately ran into a man that does not surrender his rights so easily.
No, what penal code? You gotta name a penal code that I've committed. That is the crime. Name a crime that I committed. You hear me? Name a crime that I committed other than being black and walking down this driveway.
You were detained. Behavior.
Hey, Shoemaker. Shoemaker, don't do that, brother.
Keep the look on his face. He knows what he's saying is BS, but the kerfuffle ensues when he doesn't get his usual way.
I'm finna show you guys, because you're dealing with the wrong one. That's why you guys mad at me, because you won't be able to handle me like you handle the other ones. I'm on top of my game. I know you see the gold teeth, the tattoos, and immediately think I'm another plain, normal, regular black guy. No, player, wrong one. But let me educate you guys today. Texas Penal Code, failure to identify. A person commits an offense if he intentionally refused to give his name, residence, address, or date of birth to a peace officer who has lawfully arrested the person. I am not under arrest. Once you show me that you have a legitimate reason to believe that I have committed a crime or I'm in the act of committing a crime, you know, you gotta name a penal code. What penal code do you suspect me of breaking? What crime have I committed? For you be in my yard and to be with me. You hear me?
They have nothing. That is the point.
This officer told me I look suspicious, man. I look suspicious. Walking in my own, I'm just walking down the back, I'm walking down the driveway right here down to the backyard, right? When the officer right here was passing by, this officer right here was passing by. And when he seen me, he turned around and came back. And I looked up, he already in my backyard. You know what I'm saying? I got signs. He immediately stated it. He seen the no trespassing sign.
That's correct.
He's agreeing with me. He seen the no trespassing sign and took it upon his business because he seen a black guy, I guess it's such a nice looking house, that we weren't supposed to be there. He's trespassing. He's looking to try to take something from me. You hear me? I violated no law. I haven't breached the peace. I've done nothing wrong. And he's here asking me for my information.
Yeah, that's all I need.
And I don't have to give that to you if I've done nothing wrong, sir.
For a suspicion that?
Suspicious of what?
Of being at this property.
This is proof right here, Marlon, of what we're dealing with. This is proof what we're dealing with. We got people in charge of us who don't even know the laws themselves. But I quote them for them. You hear me? I quote them for them and let them read them. You hear me? Yes, look at him.
This is sad and quite depressing. A dude doing nothing wrong, and the police trying to fabricate a story for a man to waive his rights. And they wonder why there is such distrust.
Yeah. Did you have a search warrant to come on my land, my property?
Sir, what's your name again?
Am I free or am I being detained?
Well, I just want to know your name.
Am I being detained or am I free to go?
You're free to go.
Well, I don't answer questions.
Okay.
You have a nice day. Yeah. And you see how you see?
They really tried to be slick to get this guy to give up his info.
Now look at it. Now I don't want to give him my name. He just gonna leave. I thought I was doing something wrong. If I was doing something wrong, why are you leaving away so quick? Huh? Yes.
Nice day, sir.
Why am I leaving away so quick? What's your name again, sir?
I'm Officer Ortiz.
Officer Ortiz?
Yes, sir.
Yes, this is what we're dealing with, Marlon. You hear me? We got people like him who don't even know the laws themselves. Yeah. Yeah, officer. Yeah, got him, boss. Hey, Jack, that's how you gotta handle him.
The penal code the uploader cites was the following. A person commits an offense if he intentionally refuses to give his name, residence, address, or date of birth to a peace officer who has lawfully arrested the person and requested the information.
Under the law of the land, the authority of a peace officer to arrest without a warrant is strictly narrow. At common law, a warrantless arrest for a misdemeanor is generally only legal if the offense involves an actual breach of the peace committed in the officer's presence. This serves as a crucial safeguard against arbitrary arrest on sight. This distinction is vital when dealing with modern police regulations, such as traffic laws or liquor ordinances. These are often classified as malum prohibita, acts that are wrong only because a statute says so. The common law views these as otherwise innocent acts that do not justify the violence of a warrantless arrest. Justice Carpenter of the Supreme Court of Michigan, in the foundational case Cook v. Hastings, stated, "The law governing this case is elementary, except for a breach of the peace committed in his presence, or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony. A police officer has no authority to arrest without a warrant. Without this filter, the citizen is left to the wisdom of local solons, subject to arrest for any petty infraction devised by a legislature. Even when a warrant has been issued, the law demands strict procedural adherence to protect the citizen from executive whim. A surprising but firm requirement is that the arresting officer must generally have the warrant in their actual possession at the time of the arrest. Legal history demonstrates the weight of this rule. In the Mississippi case of Smith v. State, an arrest for reckless driving was deemed unlawful because the deputy had left the warrant in the sheriff's office while attempting the arrest at the suspect's home. Similarly, in People v. Shanley, New York, the court held that a constable was not justified in arrest when the warrant was at his office rather than in his hand. The power to detain is not a final authority. It is merely a step in a public prosecution. An officer has a strict, mandatory duty to bring an arrested person before a magistrate without unnecessary delay. When an officer fails in this duty, using the time instead for booking, fingerprinting, or interrogating, they trigger the doctrine of trespass ab initio. This doctrine dictates that if an officer makes a lawful arrest but subsequently abuses their authority by delaying the judicial appearance, they become a wrongdoer from the beginning. The law is very jealous of the liberty of the citizen and asserts that detainment is not a decision of the arresting officer. If the officer chooses to hold a person in a cell for an unreasonable time without seeking a magistrate, the protection of their office vanishes, and the entire transaction is viewed as an illegal trespass from the moment the person was first touched. Good faith is no shield against false imprisonment. Perhaps the most rigorous protection of our liberty is the fact that an officer's good intentions or lack of malice provide no defense for an unauthorized arrest, because the law places the burden of legal correctness on the one who interferes with another's liberty. Good intentions are never good enough. The Maryland Court of Appeals, in Mahan v. Adam, emphasized that the good or evil intention of the defendant does not excuse or create the tort. Ignorance of the law excuses no one, and the police are held to a standard of objective legal correctness. If the arrest is unauthorized by the law of the land, it is a trespass. This ensures that the rights of the citizen are governed by stable legal rules rather than the subjective good faith of executive agents. As the law asserts, one who interferes with another's liberty does so at his peril. The common law is a jealous protector of individual freedom, established by our ancestors to ensure that the executive branch remains the servant, not the master, of the people. These ancient safeguards, the requirement of a warrant in hand, the breach of the peace filter, and the mandate for immediate judicial review, are the pillars of due process of law. In an era where the legislative mills produce more laws than any citizen can possibly know, we must decide if we will maintain these constitutional mandates or allow them to be traded for the convenience of executive efficiency. We must ask ourselves, Has modern society traded the robust due process of the common law for the mere wisdom of local solents? The answer determines whether we remain a free people or merely a regulated one.